Hi there, and thanks for attending this free webinar. My name is Randy McDonald. I'm the president of Heresy Email Services, and today's webinar topic is the legality of unsolicited mass email marketing in the US and Canada. There are two laws that regulate commercial email in Canada. The first is known as the Electronic Commerce Protection Act, or ECPA, and the second is PIPA, which is a consumer privacy law. In the U.S., it's primarily the Canned Spam Act, and throughout this presentation, we're going to be getting into the details of these laws, how they've been applied, and so forth. The Electronic Commerce Protection Act for Canada is fairly new law. It was introduced in April 2009. The law's purpose, as stated by the Canadian federal government, is to deter the most dangerous forms of spam, such as identity theft, phishing, and spyware. So this law is really not intended to outlaw commercial email per se, but more so is intended to clamp down on the things that have really given commercial email and mass email a bad name. It's been used as a vehicle for things such as identity theft / phishing and spyware, and so this is what these laws are intended to do: are to shut these things down, not outlaw commercial email per se. And we'll see that that's the same general idea as the Canned Spam Act later on. ECPA requires advance permission to send commercial email. You must have, quote, implied consent of a recipient. Now, right at this moment, this phrase implied consent is somewhat ambiguous, in that it's not exactly clear as to what implied means in terms of consent. I believe in practice that implied consent is basically when someone is interested in your product because it is something that is targeted to their needs and interests. So that's really the reason why someone would want to give consent for you to market to them, is because it's something that they're interested in. So in practice, I feel that implied consent is identical to targeted email, because the targeted message is at best welcomed, and at worst a minor nuisance cured by opting out or unsubscribing. The second requirement of ECPA is opt out. In other words, take me off the list requests are processed within 10 days. Third, opt out links must be live for a minimum of 60 days. So, in other words, the links that are sent along in your emails that are usually at the bottom, that allow a person to click a link and take it from the list, must be active for a minimum of 60 days. These things are standard with any of the email service providers you use, or if you're using an in-house software solution such as Gamadine Mailer, this will be taken care of for you automatically. Both of these requirements will be fulfilled. Fourth requirement here is that SMS, i.e. cell phone text messages, need to be permission only. The reason this is clear here is that about need to be permission only is because at this point most people are still having to pay to send and receive cell phone text messages. So people don't want to be paying for you or to receive your ads. In future, perhaps when when cell phone text messaging is basically a free thing that's included with cell phones, then this law may be relaxed. But for the time being, definitely do not be sending commercial email through cell phones and through texting. Finally, only ISPs, not individuals, can sue those they consider to be spammers. So basically, what this is saying is that unless you're causing an individual cannot come after you because you sent them a commercial email. It requires only an ISP can do that. And as you'll see as we go along, the only time that ISPs have done this is under certain conditions when they've really been hit hard by a certain spammer and really been caused financial loss. Okay, the next law in Canada that governs commercial email is what's known as PIPA. It stands for the Personal Information Protection and Electronic Documents Act. This is a consumer privacy law, and it requires businesses to obtain consent of individuals when they collect, use, or disclose their personal information. Now, my understanding of why PIPA came into existence is that it was done to protect people's what was considered confidential information, most specifically their medical and their financial information. Basically, people don't want their health and any sort of any ailments or diseases that they've ever had, being disclosed, in any way. And same with they don't want it being disclosed without their consent. They don't want this information, and same with their financial information. With all of the especially the fallout in the U.S. With people declaring bankruptcy or foreclosures or credit problems or any of this sort of thing. They don't want this information being made public without their consent. For kind of obvious reasons. So I believe that was the inception of PIPA, but it's been interpreted as sort of a more kind of sweeping, in terms of other areas of your information that you would consider personal. Now, when we talk about what personal information for PIPA is, it's been clearly stated as follows. Information about an identifiable individual, but it does not include the name, title, or business address or telephone number of an employee of an organization. So in other words, business information is exempt from PIPA, and that's why you see information being bought and sold in the marketplace when it comes to business information without restriction, because it's not considered private under privacy laws such as PIPA. Now, the U.S.'s CAN-SPAM Act, this was the original legislation that came about, which was basically what ECPA copied. Not many people know what it stands for. It's an interesting acronym. It stands for the Controlling the Assault of Non-Solicited Pornography and Marketing Act. It was introduced under the Bush administration in 2003 as a response to the growing problem with mass commercial email. And what is not well known is that basically CAN-SPAM is pro-commercial email, but it regulates it. And so these are the requirements to send commercial email under the CAN-SPAM Act. First, that you have to have an accurate email sender identification. In other words, who you're sending from must be accurate. You can't fake who you're sending from. It has to be an accurate sender in terms of the who you are, your name, your business name, and your email address. Has to be linked back to you. Number two, your subject line must be relevant to what you are including in your email. So in other words, don't make your subject line in any way deceptive about what your your intention is with your email, what you're offering, so as to entice the recipient to view email. We've all seen spammers use these somewhat deceptive subject lines to try and trick us into opening their email. Third, a physical mailing address of advertiser must be given. This can simply be accomplished by including your email signature that you normally would have in your emails. Number four, if you're offering a commercial solicitation, indicate this within the email. Number five, indicate if email's content is adult oriented. And number six, honor unsubscribes. In other words, take me off the list requests within 10 calendar days. So really, none of these requirements are really restrictive. In fact, they're actually good business practices. They're good because they are making it so that you actually must be honest and about who you are, what you're offering, and really that's the way you should be doing things anyway. So it's actually a good checklist of good business practices that you should be engaging in anyway when you're doing commercial email. Okay, so I want to talk about the legal precedents of who has been persecuted or prosecuted for email marketing or mass email marketing to date and why. Um, in the U.S., it's been the can spam infractions that people have been prosecuted under. Uh, the people who have been prosecuted under can spam are the hardcore spammers. According to various sources, apparently as of April 2008, 100 billion spam emails are being sent every day. Not many people know that there's only about 200 big league spammers in the world, and that they send about 80% of the spam that you are receiving. These people or businesses don't follow can spam with their emails. They use other people's resources for sending their emails, causing those people or businesses significant financial loss. And I want you to remember that phrase, significant financial loss, because we're going to come to it several times here. It's very important for understanding why people have been prosecuted under can spam. And they cause other businesses significant financial loss by sending excessive email to their clients' email accounts, such as AOL, which are really two things. They're basically causing them loss in the various computing resources that they have. So here's a few case studies of some of the hardcore spammers that have been prosecuted to date under can spam. First, Shane Atkinson reportedly sent 100 million messages on a quote good day advertising penis enlargement pills around 2003. Howard Carmack sent 825 million spam emails via the internet service provider Earthlink. Richard Colbert sent to 1 million general AOL email addresses advertising on behalf of other companies around 2003. Eddie Davidson promoted watches, perfume, penny stocks, junk bonds, and other items on behalf of other companies. His violation of canned spam was that his emails contained false header information, concealing the actual sender of the email from the recipient, which violated canned spam. This is around 2005. You may remember the word Javelia. This was a type of coffee that was owned by Kraft Foods. They were sued by an internet service provider called Hypertouch for sending excessive amounts of email on this coffee around 2005. Lastly here, there's many more case studies, but in this list, Davis Wolfgang Hawk, known as the Spam Nazi, he was basically a Nazi, a neo-Nazi, trying to make the final solution a reality. He spammed penis enlargement pills, and AOL also went after him for sending an excessive amount of emails to his subscribers around 2004. So what I want to talk about is what the common denominators are of these hardcore spammers. If you look back here at all those different products that we're talking about, they're all advertising in something that's very generic, something that could potentially appeal to anyone. We're talking about coffee, we're talking about penis enlargement pills, we're talking about watches, perfume, penny stocks. All of these things are either very general or things that are potentially basically fake products, fraudulent. There's the problem of all of these knockoff products out there of well-known designers, with things like watches, getting that $100 Rolex off of one of these providers. All of these sort of things are either just very generic or somewhat dubious in their value. Um, the other thing, another common denominator of a hardcore spammer is that um, because their products are generic and that they've got access to millions and billions of email addresses, they're literally sending millions of email addresses, emails a day. I know a guy that sends 20 million emails a day. It'd be hard for you to say that you have for your business uh, 20 million potential prospects that you could email a day unless you were advertising sort of anything to anyone. Um, if you're doing targeted email campaigns, you wouldn't have anywhere near this number of people that you could potentially email. These spammers are typically violating canned spam, in part or in whole, consistently. And one thing I want you to remember is that in all of these cases that have been done to date, it's the spammers that have been prosecuted, not the clients that they have sent emails for. So even after this webinar, if you're still concerned about any sort of liability that you might face in sending mass email, rest assured companies like us will handle doing the campaigns for you, although we only work in doing email marketing for the real estate business. Another common denominator is that they use other people's or businesses, companies, and resources unjustly, causing those businesses significant financial loss. Really, there's no reason for an ISP to go after a spammer unless they've done some damage to their business, whether it's they've used their resources, such as their bandwidth, their storage, if they've compromised their relationships with other ISPs, so that other ISPs are potentially blocking them, or if they've harmed relationships with the ISP's customers, where they've gotten so much spam email that these customers have perhaps left and gone with another internet provider. So that's when these ISPs usually step up and take a stand, is when it's someone that send the mass email, because of the volume of the mass email and what they've been sending has been causing them significant financial loss in some way. Now, one thing I want you to note, well, first of all, there is a larger list of hardcore spammers plus their stories at the bottom there. You can see that Wikipedia. Just type out list of spammers. These stories are actually quite entertaining, quite interesting. So if you want, you can look that up. Now, one thing I want you to note is that most of these spammer prosecutions occurred prior to 2005. There have been few since then, and I'll get into the reasons for that in the next couple of slides. What I want to talk about now is the reality of doing mass commercial email, targeted mass commercial email, and those are not contradictory terms. The reality today is that you face a very tiny amount of liability when you do targeted unsolicited commercial email, and I'll talk about the reasons for that. The reason for that is because, as I've said in the past, when the way spammers have conducted themselves is that they've done things in such a way as to cause these internet service providers significant financial loss. If AOL is receiving, say, a million emails a day, or perhaps a week, or whatever the time frame is from a particular spammer, then that in times past they've been able to say, well, yes, this has caused us a lot of harm, and it's easily quantifiable in terms of how much storage was used, how much bandwidth was used, etc. Nowadays, what's happening is that spammers aren't using the ISPs as much anymore. Rather, they are relying a lot on what are known as zombie PCs. They are spammers deliberately create and propagate computer viruses to infect individual users' PCs. And what this does is this is often found through viruses that come through file sharing networks. Um, so people download a movie or a song from an illegal file sharing network, and they get a virus, and all of a sudden, without their knowledge, their PC has turned into a mini mass mailing machine, and obviously this is without their knowledge or consent. So this is theft and fraud of computing resources, but it's been done on a smaller scale. By it's sort of like spread. The spammers have gotten smart. They've kind of spread out their liability, knowing that under canned spam that individual people cannot go after spammers. Only ISPs can. So they've decided to take advantage of that law and have it so that the individual people, as computers are going after, um, are sending out the email rather than the ISPs. Um, so so obviously this is still theft and fraud, and not a favorable business practice at all. But this is how things have changed in terms of uh, at least how they're sending the emails. Now, as far as liability goes, um, when you cause, you have to be able, if an ISP, they have to have felt that you're causing them significant financial loss, and have to be able to prove it, in terms of dollars and cents, like how much bandwidth was used, how much storage, how much of their computing resources, and or customer relationships were used and or abused by receiving um, email from a particular spammer. Now the thing is that um, as the years go on, computing resources in general have just gotten so much cheaper over time. I can remember back in the early 90s when 1 gigabyte of storage, a 1 gigabyte hard drive, cost somewhere around $2,500, $3,000. Now, today, as of May 2010, a 1,000 gigabyte drive, a drive that's 1,000 times the size, is a mere $59. So, in other words, an ISP could literally store 1,000 customers' emails and giving them a 1 gigabyte amount of storage each, and give this to them for free or have them pay for it, and it would only cost them $59, roughly speaking. So so it's getting harder and harder for an ISP. In the same way, bandwidth has gotten much cheaper, especially when bought in volume, like these ISPs can. Um, it's getting harder and harder for an ISP to really say that anyone that's sending any amount of email has caused them significant financial loss by using their resources. But as I've said, if you're doing targeted, you know, um, mass email marketing where you're only sending in perhaps say like the tens of thousands, or most the hundreds of thousands of emails every few days, or perhaps every and nowhere near the multi millions that these other guys are sending, then it's even more difficult for an ISP to ever come after you and say that you've caused them significant financial loss. So I believe this is why you're seeing relatively few prosecutions of spammers since 2005, because basically bottom line is that computing resources have got so inexpensive over time that they can't really make a case for having significant financial loss by these spammers since then. Now, lastly, here, what I want to do is talk about. It's one thing to be legally compliant, and I've pretty well covered the what you need to do for both the U.S. and Canada to be compliant with email campaigns. But you also need to be compliant with your internet and email providers. So if you're going to be sending any large quantities of commercial email, you definitely do not want to be sending it through your internet service provider's mail server. Um, they have, because of of these mass emailers in the past, um, they have pretty much outlawed any sort of mass commercial email. Often, even if it's opt-in to a large extent, it violates your ISP's acceptable usage policy and terms and condition that you agreed to buy when you signed up with them. They are very intolerant in general when you get a spam complaint. If you don't have explicit proof of someone that's opted in, um, then they it's within their rights to revoke your internet access. And if you have your website with them, you can have your hosting terminated so that your website is effectively gone. Same thing with your your domain registrar. They can revoke your domain as well. So definitely do not send mass emails through your internet service provider. You also do not want to send them through your email provider. So this could be, for instance, if you're, say, signed up with a GoDaddy, or if you're sending them out through, let's say you have a Hotmail account or a Yahoo account. It's the same thing here. Very, very little tolerance. They don't want their networks being used. They were. It was bad enough when the networks were being used to receive tons of spam email, and they still do. But they definitely don't want to be used for sending, because that's even worse for them. Because if they are known to be sending mass email and getting blacklisted because of the email that you're sending, that is definitely something that is causing them significant financial loss. If a major provider, like if your internet provider was to get blacklisted, by a major network such as AOL, for instance, where none of the emails from that ISP or were being received by AOL, that is definitely um, a big thing, and something that is you don't want to have happening. So long and the short of it is, do not use your internet service provider, do not use your email provider to send really to send any quantity of mass email campaign, because both of them have very little tolerance, if not zero tolerance in most cases, for spam complaints. And even if you have an opt-in list, people are known to make spam complaints. So what you need to do is you need to use an email service provider, and who is mass email friendly and understands and is able to deal with the occasional spam complaint. If you're going to be doing it on your own, you want to have your own dedicated server, and you want to have your own private IP address. You don't want to be using a shared IP address, such as what you would have with like a constant contact. Same reason being is that it's the same idea when IPs are shared by, whenever you have a situation where a number of people are sharing an IP address to send email, if one person causes problems with the IP address by getting spam complaints and blacklisted, it causes problems for anyone that's using that email or that IP address to send or receive. And this can literally be thousands of people, if you're using a large provider such as Constant Contact. So if you have your own, in any case, if you're going to be doing in-house and you want to use your own software, have your own dedicated server, have your own software. I recommend Gamma 9 Mailer, and have your own private IP address. If you're going to be using an email service provider, make sure that they're a company that will give you your own private IP address as well. All the specific how-to info you need on how to send targeted mass email is available in our webinar, aptly titled "How to Send Targeted Mass Email Campaigns," which is also available on our website in the webinar section. And I want to leave you with this quote here. If a person says he hates spam, then he means he hates advertising, which he sees everywhere. And that's the end of the webinar. Thanks for attending. If you have any questions, there is my contact info. Thanks for watching, and have a great day.